Okay. Dealing with Court Branch D, which is basically the court branch that deals only with child abuse and the rules and regulations therein. Continuing that. Any court employee or court-affiliated person who recommends foster care for a child or children who have a loving, non-abusive, and reasonably capable parent to live with shall receive the worst penalties possible from A, the overseers against corruption who take care of court corruption. The idea behind this is that giving penalties to people who put children in foster care unnecessarily will help stop the burden on the foster care system. Something like 70 to 80% of current prison inmates were former foster care children. The system is overburdened with foster kids, and we don't need kids in foster care who don't belong there. It wastes tax dollars, it wastes time, energy, money, etc., etc., etc. And it does not encourage the children to feel well later on in life. So if one parent is convicted of abuse in Court D and the other one is not and is a loving parent, the children should go to the good parent. Okay. Any court employee and or court-affiliated person who maliciously and or willfully disobeys or tries to prevent the application of the forestated rules for Court D shall be subject to the loss of job and massive fines and or any other penalty that A, overseers against corruption, see fit to implement. Finally, it will be seriously offensive and illegal for judges in D cases against child abuse not to pay close attention to correspondence of any type from children involved in court cases. The reason I would make that illegal is I wrote letters to the judge. I know other kids in other cases who have written letters to judges, and nobody pays attention to what they say. Kids are not stupid, and they know what's right and wrong, and they should be listened to. And if people don't listen to them, all you're going to get are crazy, corrupted adults who have their own agenda, who say it all in the name of the best interests of the child, when really it has nothing to do with the child at all. That needs to stop. So there are the regulations for Court D that I've proposed. As I said, A is above D. D is above Court Branch C, which is the new court branch I'm getting ready to talk about. Court Branch C is a court branch which would deal with regular divorces, alienation cases, and violence between parents cases. Not cases where parents are abusing their children. Only cases where violence is perpetrated solely between the parents. Okay. These people in this court would receive less payment than in Court A or D. They would get more payment for difficult cases in this court with alienation and violence against between parents cases. Those would give more bonuses, just as child abuse cases would give even more bonuses in Court Branch D. There would be no legal immunity for judges, magistrates, referees, lawyers, psychologists, psychiatrists, and or any other court-affiliated person. That would be the first rule for Court Branch C. A panel of 2 or 3 judges would be randomly picked out of a hat full of a list of judges specially trained to deal with alienation cases and violence between parents cases. All mental health professionals involved in type alienation 2 and 3 cases, so alienation and violence between parents cases, would be randomly picked out of a hat full of lists of mental health professionals specifically trained to deal with alienation and violence between parents. The idea behind this is nobody's handpicked, there's no favoritism, it's harder to bribe people when there are 2 or 3 judges on a panel. It's harder to bribe psychiatrists and psychologists who you don't know. It's harder to do these things. The more people there are, the better. Well, that's the reason also for Court A, or the overseers, is that you can appeal to them if there's any problem in any system beneath them. That's less powerful. Okay. Nobody apart from lawyers shall be hand-picked. All other persons in C cases shall be randomly pulled from court lists. All trained professionals dealing with the same issue, trained specifically to deal with the same issues. Both plaintiff and defendant shall both pay 50% for each mental health professional that is randomly included in the case. All fair, financially fair for everybody. No court personnel, in or related by extension to the court, shall give time favoritism or emotional favoritism. All decisions must be thoroughly backed up by sound logical testimony and logical backed up psychological evidence. Any court personnel or court-related personnel, or court-related personnel who breaks these rules shall be subject to loss of job and major fines imposed by A, Overseers Against Corruption. In cases of domestic violence between parents, in which violence only exists between parents, but no violence exists between the parents and the children, the parents shall each pay 50% for a court-appointed supervisor whose job it will be to pick up and drop off children for visits between the parents. The idea behind this is to prevent children from witnessing domestic violence between their parents. So many times when there's domestic violence between the parents, even if it's not perpetrated on the children are given to one parent or the other, which is not good for the kids if both parents are loving. This is a simple solution with a simple, neutral pickup person to bring kids to and from one parent to the other. So that way there's no more witnessing of domestic violence for the children. And they can both have both parents can have a relationship with their children in that manner. Okay. Domestic violence evidence that precedes divorce may be presented as evidence after divorce. There are too many cases where people are being beaten half to death and they get a divorce and they go into divorce court and they find out that their abuser has a clean slate now just because they've gotten a divorce. They have no way of leaving their abuser because the abuser has no record anymore. That's not practical for eliminating crime and problems in society. We need a system where all evidence can be presented. That doesn't mean all evidence is always believed, but that does mean that all evidence is presented, and if it's logical, then there's reason to believe it. Okay. If any evidence is presented of abuse towards the children, which occurred prior to divorce, then the judge or judges in Court Branch C shall have the duty to transfer these cases to Court Branch D, which deals specifically with child abuse. Punishment given by A will fall on any individuals who possessed knowledge of abuse prior to divorce and fail to transfer such cases to Court Branch D, to be properly dealt with as child abuse cases. Any case in which a parent claims the other parent has threatened to take their children's lives and evidence is presented that shows that the threatening parent has a police history and or a history of severe mental problems shall be immediately transferred to Court Branch D with a letter of emergency attached to the case. Any court individuals or court-affiliated individuals who fail to transfer such cases to D shall suffer severe consequences imposed by A. So, if they don't transfer it to the court with child abuse issues, then the overseers can have them punished. The idea behind this is so many times the court is responsible when children die because they don't pay enough attention to situations that are potentially dangerous. The court can't prevent something when a person seems totally normal and they don't have a violent history and they do something violent one day. The court cannot predict that or prevent it. But in cases where someone's threatening to take kids' lives and in which they have a violent history or have a history of insanity that's really severe, there needs to be protection for these people. So they need to go to a court branch that will protect them. Okay. Okay. In cases involving alienation, the general solution shall be to court order the parties into intense therapy under the guidance of specially trained mental health professionals. However, Court C shall be required to transfer alienation cases to Court D if a child or children are or have become suicidal as a result of alienation. Finally, any child or children being severely alienated, but not to the point of becoming suicidal, shall be given the right to choose to live with one parent as opposed to the other before turning 18 years old, but after the children have reached an age of reason. Any court personnel or court-affiliated personnel found to be in malicious, illogical noncompliance with these orders would face severe penalties doled out by A, the Overseers Against Corruption. The idea behind this is that forcing children to live with severe alienation can lead them to suicide. It's a form of mental abuse and emotional abuse when it gets to that point. It is abuse as it is. It's abusive, but if the abuse is that severe, then the child's relationship with the alienating parent probably cannot be salvaged, is what I'm trying to say. That's not to say that alienation is not a kind of abuse, but I think it should only be classified as severe mental abuse if the children are becoming depressed and suicidal and whatever else because of this. There'd have to be lots of evidence of that before transferring it to Court D. However, that doesn't mean the standard should be so high that they're never transferred. That wouldn't be right either. So that's something that should be dealt with and would be logically dealt with that way. Likewise, telling children that they have to live with an alienator until they're 18 years old, if it's driving them crazy, they should not be forced to do that. They should have their own choice. If it's severe enough to warrant that. Now, most cases probably could be solved with intense therapy. I don't know. That would be a psychiatrist or psychologist to determine these things. Okay. Court C shall have the duty to take into account the financial status of the individuals before them, especially in cases involving child support. More rigid consequences shall go into place to enforce child support laws against those who maliciously refuse to pay. On the other hand, those who honestly can't pay shall be given great leniency. Judges and referees who improperly fail to follow guidelines concerning child support shall be subject to penalties from A. Too often, you have poor people who go to jail because they can't pay, and they really can't pay because they are broke. On the other hand, you have people who are riding around in Mercedes cars, limousines, and God knows what else, wearing practically gold jackets, and they claim to be poor, and the court lets them just walk all over everyone and slide away. That needs to stop. It shall be the specific duty of Court C to enforce equal parenting except in cases which have been transferred to Court D and abuse has been confirmed. Cases of corruption that are before A and alienation cases in which the children have reached an age of reason and chosen not to visit one parent. Any court personnel who fail to enforce equal parenting except in the any court personnel who fail to enforce equal parenting except in the exceptional cases cited above shall be subject to severe penalties by A. So if the kid has not reached an age of reason, if they're not suicidal, if there's no abuse, and so on and so forth, it will be the duty of C court to enforce shared parenting, equal parenting. In this way, kids who should have a relationship with both parents will get that relationship. On the other hand, if there's an abuse claim, that needs to be taken seriously. The court regulations would be about the same. If someone's bringing forward false abuse accusations all the time to keep the kids from the other parent, then the court D would deal with that accordingly. Otherwise, it would go through the normal regulations. If abuse were found, they would never have to see that parent again. In fact, they would be ordered not to see that parent again until they were adults and could handle it. So that's the idea behind that. One court branch would deal with alienation and stuff like that and equal parenting, and the other deals with abuse, where equal parenting is not beneficial. And in fact, visitations are not beneficial. Okay. So, since the objective of Court C shall be to enforce equal parenting, it will be a major offense to involve CPS in any way, shape, or form. Any C court personnel found to be engaging CPS in any manner shall be subject to massive fines and loss of jobs imposed by A, the Overseers Against Corruption. The idea behind this is that CPS is not to be removing these kids because these are not abuse cases. All D and A proceedings, so that's the Overseers and the Abuse Court, and decisions shall take precedence and priority over Court C. Court C shall be subject to all decisions from A and D unless A overrides D decisions, in which case C shall be subject to A. Court C shall not involve itself in any D cases, and all previous C verdicts shall be null and void until or unless A or D sends the case back to C to be judged. All cases in which abuse is deemed to have occurred are none of C's business unless A changes the final rulings and sends the case or cases back to C. If C breaks any of the rules just stated above, C personnel would be subject to massive fines and or loss of jobs. Any persons found to be hiding or refusing to hand over tapes or files to the litigants or to Court A would be subject to job loss and big fines. As I mentioned previously, and I will mention again, like in Ohio, they take tapes, they take papers, and they make them disappear, and because of that, you do not have the right to appeal. This is not practical. All ex parte hearings would be strictly forbidden. Ex parte hearings are not beneficial, it's biased, it's wrong, people get in the one side and not the other. It needs to stop. Okay. So, oh yeah, finally. It would be considered seriously offensive and illegal for judges not to pay close attention to correspondence of any type from children involved in court cases. The reason behind this is that too often kids write letters, they're telling the truth, and nobody pays any attention whatsoever. And this ruins kids' lives, and it could be prevented. Okay. CPS and the regulations therein has the right and is encouraged to give social aid to the poor. Too often children are taken away and aid is not given, and because of this, the foster care system is way overloaded. That's not practical. Not everyone's a bad parent because they're poor. And in fact, poverty should not be the standard for child abuse or being a bad parent. has no legal immunity for anyone in or related to CPS. That would be the other rule. Children may not be removed without reasonable proof of abuse coupled with reasonable proof of malicious intent. Too often children are taken away and there's no malicious intent. In one case I heard of, they claimed the child was taken away because someone tripped over a cord and fell on top of the child and the kid got hurt, so they decide that the people are abusers because of that. Greg Pound's story. Is it true or not? I can't say for certain, but what I can say is if a child gets a dog bite and it's an accident and the parents are not just leaving dogs around their kids all the time, they should not have their kids taken away for a one-time accident. That does not make them bad parents. Do you know any child or children who have not had a dog bite or cat scratch or some injury of that sort in their whole childhood? It's hard to find any children who didn't. So that's something that needs to be addressed. No more removal of children without proof of malicious intent. CPS involvement in D cases will only come at the close of the cases and only at the written request from the panel of judges. CPS may give no psychological opinions, requests, nor opinions of any sort in D cases. CPS's only purpose for involvement in D cases is to remove children from the environment the panel of judges voted against to the specified environment the panel of judges voted for. The panel of D judges must each specifically, clearly, and in writing give the reasons for the said removal of the children from one environment, along with the reasons they believe the new environment is better for the children. Anyone in or affiliated with CPS who removes or attempts to remove children without a letter from each judge in the panel of D judges, or who disregards a given vote, will be held responsible for all damages caused and will be referred to A to be fired or fined. Any involvement of CPS in Court C and any bad involvement in Court D will result in major fines and loss of jobs for those involved. CPS will be forbidden to render any opinions about any proceedings in Court Branch C or D in any way, shape, or form. The most CPS may do is obey removal orders from Panel D judges and refer child abuse cases to Court D, which aren't involved in divorce proceedings or custody disputes. Any children being mistreated in foster care could appeal to A and may provide names of bad CPS social workers to A. The idea behind this is that social workers who ignore children who are being abused in foster care could no longer get away with it, because the children could go to the overseers against corruption and ask for changes, and the changes could be applied. CPS should provide programs to aid foster children who age out of the system. Kids who go through foster care are often dumped on the street when they turn 18 with a little bag of goodies and told to find their own route. That is not constructive for society. Just because they're 18 doesn't mean there's a magical wand that was waved over their head that makes them perfectly capable of taking care of themselves and knowing how society works. Schools do not encourage children to live in the real world often enough. They tell you how to behave in a classroom. Excuse me, but a classroom is not the same as what you get going down a street, working in an office, etc., etc., etc. It's not the same environment, therefore it doesn't teach children enough about reality. And the foster parents aren't there always giving them lessons about the future and every little detail about how to fill out a medical form, for instance, or things like that. Kids don't just magically know this when they're born. Okay. I have something to read off the computer. I will do my best. What I wanted to read was this. I am not for the father's rights movement or the mother's rights movement because there are both good fathers and bad fathers. just as there are good mothers and bad mothers. This, however, doesn't deny the plausibility that the percentage of women being harassed in court is probably higher than men, as socioeconomic issues could certainly contribute to court biases. However, from my personal experiences and observations, I've come to believe that most court damage is caused by errant psychological theories. One of the most frequently used theories used in court cases is parental alienation syndrome, first referred to by Dr. Richard Gardner. PAS has been extensively criticized by numerous mental health professionals at large for several of the following reasons, which, interestingly enough, supporters of PAS don't or can't deny are based on facts. First of all, Dr. Gardner's theory wasn't peer-reviewed by anyone in the acceptable realm of mental health professionals. Instead, he merely supported his theory by seeking and accepting praise from individuals who already supported his theory. Secondly, Dr. Gardner claimed that the majority of parents seeking to alienate their children from the other parent are mothers, although he could produce no studies conducted by himself or others to back up this claim. Finally, Dr. Gardner's theory presents the false assumption that if alienation from one parent is confirmed, then abuse allegations directed at the opposite parent are false. This is very dangerous, as it can lead judges and mental health professionals to the erroneous assumption that a child can never be manipulated by one parent while simultaneously being abused by the other. This is exactly the faulty logic that led to illegal decisions in my mom's court cases and subsequently mine. The idea that if my mom were found guilty of alienation, that all of my abuse claims against Bill must be false is simply absurd. Most pathetic is the glaring fact that none of the charges leveled against her were proven to be true. My points of contention mentioned above are merely the issues that PAS supporters will address, but there are many more points that critics, myself included, have highlighted. I shall point these out in the following. First of all, PAS isn't a proper diagnostic evaluation tool, but rather a list of symptoms. Like any list of symptoms, it is subject to personal interpretation. For example, hostilities towards a parent can be caused by abuse or alienation. The observation of hostilities alone are insufficient grounds to affirm absolute PAS. Secondly, Dr. Gardner's famous quote, "There's a little bit of pedophilia in all of us," doesn't hold water, since he never once in all of his writings gave a truly critical analysis of what exactly constitutes normal sexuality in the first place. Such a claim would have sounded even more absurd if the word pedophilia were placed with homicidal tendencies. Naively applying an abnormal behavior to a general situation is called the fallacy of generalization in philosophy. An amusing example of this thinking can be observed in the following example. Alcoholics drink alcohol. Therefore, anybody who drinks alcohol is an alcoholic. Thirdly, among Gardner's other unusual ideas about human sexuality was his belief that sexual relations between parents and children is a healthy demonstration of reproductivity in the population. This is disconcerting to me because I realize that this line of thought could well be used to psychologically excuse a number of behaviors that deviate from a moralistic and constructive norm. This kind of argument could be used to suggest that murder, stealing, prostitution, and selfish dishonesty are all, at their psychologically underlying core, basically normal behaviors. By this line of thinking, any murder that occurs in a populated area could be considered a psychologically normal means of population control. Stealing could be recoined as the proactive distribution of wealth. Prostitution would be redefined as normal sexual expression that encourages baby booms. And finally, selfish dishonesty could be retermed population control / survival of the fittest. I suppose it's of little surprise that the children whom corrupt courts and CPS workers forced to live with their abusers under the guise of Gardner's PAS theory often